Section 36 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 15, General Conclusions, Part 1. Before concluding this essay, it may be well in a final chapter to consider its results in their bearing upon the conditions of early Anglo-Saxon society, and especially with regard to the division of classes and the character of the holdings. The object has been to approach these difficult questions from the point of view of tribal custom. The main clue to an understanding of the division of classes has been the amount of the vergels. The trouble taken to arrive at a correct knowledge of the currencies in which the vergels were paid, tedious as it may have seemed to the reader, will not have been thrown away if it has led to the recognition of the fact that there was a very general correspondence in the amount of the vergels tenaciously adhered to by the tribes of Western Europe, whether remaining in their old homes or settled in newly conquered countries. The amount of the vergels was not seemingly a matter of race. Cymric and German customs were singularly similar. If the Irish Eric Finney formed an exception, Irish tribal custom nevertheless had many things in common with Cymric and German custom in other respects. It was from a study of the vergels and the rights and liability of relatives in their receipt and payment that some idea was gained of the solidarity of the kindred under tribal custom, and this solidarity of the kindred was found to be closely connected with the family character of tribal land holdings, of which the Cymric Welly was a typical example. Where direct evidence of this family element was wanting, the liability of the kindred for the vergeld remained as an indication that it once had existed. In reviewing the evidence of these matters and attempting to bring the results to a focus, we begin with the fact that with comparatively few exceptions, the normal vergeld of the full or typical freeman was everywhere so large, 200 gold solidi, the heavy minute of gold, traditionally representing 100 head of cattle. This vergeld was too large by far for the individual slayer to pay, and possible only as a payment from one group of kindred to another. We have seen reason to infer from the Kentish, Wessex, and Mercian vergels that the Anglo-Saxon tribes shared in these traditions, and, so to speak, brought their vergels with them into Britain, and we have found that Anglo-Saxon custom as regards the vergels was substantially similar to that of the continental tribes. From Beowulf we learned that, as there could be no feud within the kindred, a homicide within the kindred could not be avenged or compounded for. There was no galanus or vergeld in such a case under either Cymric or German custom, and evidence was found in the so-called laws of Henry I that it had been so also under Anglo-Saxon custom. Up to the time of the Norman conquest, the punishment of parricide was practically left by the laws to the spiritual jurisdiction of the Church. The principle which required both paternal and maternal relations to join in the payment and receipt of vergels, and nearly always in the proportion of 2/3 and 1/3, was also common to Cymric and German tribes. This principle depended upon a view of marriage likewise common to both. A blood relationship was established as regards children of a marriage, while husband and wife for many purposes remained in their own kindreds, there being no blood relationship between husband and wife. The husband's kindred alone were liable for his crimes, and the wife's alone for her crimes, and neither the husband nor the wife received any portion of the other's vergeld or was liable for his or her homicides. Such was the custom under the Cymric codes and the laws of the Brets and Scots, and Anglo-Saxon custom as described in the so-called laws of Henry I was similar. The tribal feeling which allowed tribesmen and strangers to live side by side under their own laws, and made the Salic and Ripuarian Franks award a full Vergeld to tribesmen of allied German tribes, while it gave only a half Vergeld to the Gallo-Roman possessor who was not of their blood, was, it would seem, brought with the invading tribes into Britain. Danish and English tribesmen were allowed to live side by side under their own laws and acknowledged as equally dear with a similar Vergeld, while, at all events in the cases which come unto notice, complete strangers in blood were awarded only a half Vergeld, as in the continental laws. We have not attempted to settle the question how far there was a Romano, British population left in the towns, but we have found incidental traces and hints that in Northumbria, Wessex, and Mercia, there were Willis men, Welsh or British, who had only a half Vergeld, being treated as strangers both in this respect and also as regards the substitution of the ordeal for the oaths of kindred. The principle that a man who could not bring to his protection the oath of his kinsman must be brought to the ideal was one of widely extended tribal custom, and it was emphasized by the adoption of the ordeal as a Christian ceremony solemnly performed in the churches under both Frankish and Anglo-Saxon law. There can be little doubt that in the solidarity of the kindred under tribal custom, we have to do with the strongest instinct which everywhere molded tribal society. So far as it had its way and was not confronted by more potent forces, it must have almost necessarily ruled such matters as the division of classes, the occupation of land, and the modes of settlement. When we inquire into the grades of society under tribal custom, they seem everywhere to have their roots in the principles of blood relationship. A man who has no kindred to protect him needs and seeks the protection of a chieftain or lord. By the force of tribal gravitation, he sinks into the dependent condition of living upon another's land. Whether he be a freedman who has risen from the rank of the thrall, or a free tribesman of low position, or one of a conquered race, or a stranger immigrant, and whether he be courtier or the holder of the typical yardland, until in the course of generations a kindred has grown up around him, he remains in the dependent condition. He is indeed a freeman as compared with a theo or thrall, but when Alfred and Guthrum made their compact and agreed that Dane and English shall be reckoned as equally dear as the normal Vergeld of the full freeman, it is not of the dependent class they are thinking. They give to this class and to the Danish lessing, or newly made freedman, a twihind instead of a 12-hind Vergeld. It might at first sight be supposed that this twihind condition of the dependent class in England, so far as it may have included Anglo-Saxons, must have been the result of degradation in social status between the first settlements in the time of King Alfred, but we have sought in vain for evidence of an earlier higher position in the laws of King Ini. And on the whole, even when regarded solely from a tribal point of view, it does not seem unlikely that strangers in blood and freedmen and dependent followers of the conquering chieftains should find themselves after conquest and settlement in the economic condition of tenants and gelders on the lands of protecting lords. Nor would it be strange that, when in a new country and under other influences, this uniform dependent economic condition had once become a general fact, the whole class, in spite of variety of origins, should find itself marked by a twihind Vergeld. It does not follow, however, that because in the compact between Alfred and Guthrum, the twihind class were reckoned as equally dear with the Norse lacing, that the Anglo-Saxon Curl, who sits on Garfold land, was generally in as low a social position as the Norse newly made freedman. It is enough that according to the evidence, he was a dependent tenant, let us say, under the lordship of a 12-hind man, or of settled upon royal demesnes, of some geseth, or official of the king. Still, it may be well to look once again at the position of the Norse lessing, because after all, it is with the lessing that the Anglo-Saxon twihind gafagelda was equated in a compact made after King Alfred's victory, and so when the two chieftains seemed to be treating on equal terms. Surely King Alfred was not intending to degrade the Anglo-Saxon dependent class. Presumably he was making a good bargain for them. The early Norse laws were settled long after the date of this compact, upon the conversion of South Norway, and, as in other cases, they were framed with the express purpose of making room in the legal system for the Christian Church, and so in some sense with its sanction. And yet so deep was the gulf between classes, even then, that a certain portion of the churchyard was set apart for lessings, and in no case were they to be buried in the portion reserved for classes above them. And if, after giving his freedom ale, and so attaining the first step in freedom and independence, the lacing should die, leaving destitute children whose support ought not to be thrown back upon his lord, we have seen that the way out of the difficulty was to dig a grave in the churchyard into which the lessing's children were to be placed, and left to starve to death, the last survivor being the only one which the Lord thenceforth had to maintain. This was the position of the lacing at the bottom of the ladder of freedom. But we have found the lacing of the Norse laws rising by steps into greater freedom and better social position, and the process throughout was founded upon the gradual growth of kindred. It was the lack of kindred to swear for them and defend them which placed them low in the social scale, and it was the gradual growth of kindred generation after generation which marked the steps of their rise into better social position with higher virgals. When we turn to the Anglo-Saxon laws, we seem to detect similar tribal principles originally at work but with differences, which may very probably be referred to the circumstances attendant upon conquest and settlement in Britain. The law of tribal gravitation here as elsewhere, aided no doubt by other potent forces, had been at work placing the man with an imperfect kindred in a dependent position at the bottom of the social ladder. And it is important to note that at first the middle rungs of the ladder by which a man could climb out of the dependent position seem to have been present here as in Norway. The evidence is scanty, but sufficiently important. From the Kentish laws, the presence of stepping stones into greater freedom may be inferred in the case of the three classes of lets, with their rising virgals, and in a precious fragment of ancient custom happily rescued from oblivion, we find evidence that, originally at all events, there had been a way out of the curls twi-hand condition of the fourth generation of landholding, connected with payment of gafal to the king's utware, and direct service to the king. But we recognized that the collector of the fragment looked longingly back to ancient custom, speaking of it in the past tense, as if it was no longer in force. It would obviously not be wise to trust solely to the negative evidence of the silence of the laws, but in this case the silence seems to confirm the evidence of the fragment, for the pathetic tone of the fragment finds an echo in the fact that all traces of the middle rungs in the ladder seem to have vanished from the later laws. There is no mention of Inni's laws or in Alfred's of there being or having been several grades of freedmen or lets. Even the half-vergeld of the sixth hind stranger, who has risen to the possession of 5 hides, silently disappears after King Alfred's time. From whatever cause, so far as the evidence goes, the twi-hind class seems to have become a homogeneous class in which, in spite of different origins, distinctions were merged in a common economic condition. Differences of origin were perhaps forgotten as the result of comradeship in the long struggle against the Danish foe. We thus seem to be driven to recognize the width and to some extent the bridgelessness already in King Alfred's time, if not in King Inni's, of the gulf between the position of the 12-hind landed class and that of the twi-hind dependent class, Agafagelders, and Gebers, who were tenants on their land. It seems probable that, though technically and really free in the sense of not being thralls, the twi-hind class, broadly speaking, may have found themselves very early, if not from the first, placed in an economic condition of service and servitude, including work as well as gaffal, which, by the ultimate difference of the middle rungs of the ladder, might very easily slide into what is loosely called the serfdom of later times. In the meantime, we realize that the abjectness of this semi-servile condition may be very easily exaggerated by modern associations with the terms service and serfdom. It is when we turn from the twi-hind class to the position of the class above them, of Gesekund and 12-hind men, that we learn that a part at least of the risk of misunderstanding may lie in the difference between the tribal notion of service and freedom and the more modern one. What, then, has tribal custom to teach us as to the position and services of the 12-hind class? Reverting once more to the combat between Alfred and Guthrum, Dane and English are to be equally dear at 8 half-marks of gold. The Englishman, without any limiting adjective, is the 12-hind man, and he is put on a level with the Danish typical free landholder, the Hald or Alderman of the Norse laws, whose vergeld under Norse law was that of the typical freeman everywhere, equivalent to the normal vergeld of 200 gold solidi, the mina of gold, the traditional vergeld of 100 head of cattle. It was 6 times that of the Norse lessing, just as the 12-hinderman vergeld in England was 6 times that of the Kerl who sits on gaffald land. The English 12-hind man is therefore put on a level with the Norse odeler, or typical landholder, and so, as we have seen, the Kerl who rose by the middle rungs of the ladder into the 12-hind position had inter alia to become a landholder of 5 hides, and his family became gesticund only after the landholding had continued to the 4th generation. His great-grandchildren then became gesekund with the 12-hind vergeld. The 12-hind men were therefore landholders, surrounded in principle at least, if not in practice, by a kindred. But what kind of a landholding was it? Approaching the question strictly from a tribal point of view, the solidarity of the kindred involved in the payment and receipt of vergelds would certainly suggest that those who had a right to receive and the obligation to pay held a position in their kindred quite different from that of the modern individual owner of land. The analogy of Welsh and Irish and Salic and Norse and Scania tribal custom would lead us to infer that the Anglo-Saxon settlers in England must have brought with them traditions of tribal or family ownership more or less of the type of the Cymric Gweli, though doubtless modified by emigration and settlement in a new country. After all that has been said, traditions, perhaps actual examples of the individual ownership of the Romanus Processor, and still more likely, actual experience of the Roman type of landed estates, may have survived in Britain from the period of the Roman occupation, and the Anglo-Saxon settlers may easily have been influenced in the matter of landholding by what, as conquerors, they came to supplant. But they can hardly have wholly cast off their own tribal traditions and instincts. The continued payment and receipt of vergelds shows that they did not. Even, to take an extreme case, if they came to Britain as single settlers, having left their kinsmen behind them, still kindreds would gradually grow up around their descendants in the new country, and tribal custom left to itself would give to them landed rights, quite different from those of the individual owner. But the interval, apart from other outside influences, may well have subjected tribal custom to a strain. From the point of view of this interval, it may not be unreasonable to revert to the clauses of King Alfred's laws on kinless men, and the Norman precedent, that the king was to take the place of the missing maternal kindred and of advocate for a Norman if he had no other. Unless, therefore, the 12-hind settler was surrounded by a full kindred in the new country, he must, according to his own tribal custom, had found himself much more of an individual than he was used to be, and therefore more dependent upon the protection of his chieftain or king. We must not, on the one hand, conceive of the 12 Hin settler as having all at once adopted the independent position of the Roman possessor, though circumstances may have sometimes severed him as completely from his parentia as the ceremony of the Salic law. Nor can we, on the other hand, conceive of him always as the tribesman surrounded by his kindred. He may evidently, on the one hand, be released from many of the trammels involved in membership of a kindred, but on the other hand, he is thrown more than ever under conditions of service to the king. Let us for a moment revert to the tribal conception of these trammels and services. They did not always involve degradation of social condition. They often, as we have seen, were the mark of the attainment of a higher position. The kindred of the Alex or strangers who settled upon a chieftain's land under Cymric custom was acknowledged in the 4th generation of continued occupation, but at the moment a kindred was acknowledged, its members became adscripti glebbi. When the Irish Fudir did the same, his descendants of the 4th generation found themselves not only bound to the land, but also bound together by something like the rules of the Cymric Gwali, so that one of them could not sell or charge a share without the consent of the others. We found the same thing in Norway, where the rules for payment of the vergels by relations were more elaborate than anywhere else, and where the growth of kindred seems so completely to have ruled the rise from one social grade to another, till at last a man whose great-grandfather's great-grandfather was a freeborn landholder became an odler. If at first sight we were to picture the odleman to ourselves as an individual freeholder of Roman or modern type, we should soon find out our mistake when we learned that if he wanted to sell his odel, he must first consult his odel sharers. When examined closely, the fact became evident that it was the group of kindred that by long settlement on the land had become odel, and that the shares of individual in the odel were subject, with, of course, many differences, to some such tribal customs as those of the Cymric Gwali. The odleman was thus not a single isolated landowner. He was surrounded by kindred odel like himself, reciprocally bound to fight for one another and swear for one another, and to share in the payment or receipt of one another's vergeld. The odleman was protected by his kindred, but his freedom of individual action was restricted by it. So also under Salic law, the joint inheritors of the alod or terra salica, with right of redivision between great-grandchildren per capita, were in the same way trammeled. And when, by a solemn public form, they released themselves from their obligations to their kindred, they relinquished also all rights of inheritance and protection. Are we to consider these continental analogies to be without relevance to Anglo-Saxon landholding? Dr. Conrad von Mora, in those masterly papers, contributed in 1855 to the Christian Oberschau, which are still so valuable, rightly lay stress upon the power of the kindred as the great rival of the power of the state in the development of Anglo-Saxon polity. We find but little direct allusion to the kindred in the laws, it is true, but incidentally, and as it were by accident, we have learned from passages mentioned in their proper place. As the time of Athelstan, there were kindreds both 12 hind and twi-hind powerful enough to defy the king's peace. This is in itself a significant reminder that more or less of tribal custom remained in force behind the screen of the laws from which most of our evidence has been taken, and yet we seem to be almost forced to the conclusion that if we try to realize the position of the 12th hind settler, we must regard him at all events for the first few generations as in a very different position from that of the Norse odleman in the old country, even though as head of his family he may have brought descendants and dependents with him. He could not in the new country be at once surrounded by kinsmen and odel sharers, who with himself had hereditary rights in the land. We thus come round again to the point that so far as he may have been separated from his kindred, the first Anglo-Saxon settler must have found himself thrown upon the protection of his chief and into a position of individual service. He becomes, as we have seen, according to the scanty evidence of the laws of any, a king's guesseth, with military and judicial administrative duties to discharge, put into a post of service which he cannot relinquish at pleasure. Service to the king has to some extent taken the place of the restraints of kindred, and so in a sense, like the Twyhind man, he has become a gaffagelda, but paying his gaffal and services direct to the king, an eter scriptus glibby, but tied to an estate in an official position instead of to a yardland. This view of the position of the Gesigkund and 12 Hind class rests very much upon the incidental evidence of the dooms of the Idi, but the truth of it is confirmed by the independent evidence of the precious fragment already referred to, for its interesting evidence shows that, in addition to his holdings of 5 hides of land, it was precisely into this position of gaffal paying and service direct to the king that the curl of ancient custom had to climb in order to earn the Gesigkund status and the 12 Hind Vergeld. Thus we arrive at a definite and practical mark distinguishing ultimately, and perhaps more or less from the first, the 12 Hind and Twyhind classes. The 12 Hind, or landed class, paid gaffal and did service direct to the king. The Twyhind, or dependent class, paid gaffal and did service to the landed class, who from this point of view were middlemen between the Twyhind gaffagelda and the king. We seem, therefore, thus early to arrive at something analogous to Professor Maitland's technical definition of the manor as the fiscal unit from which gaffal is paid direct to the king, while its lord is the receiver of the payments and services of its tenants. The single landholder, who is not under a manorial lord in the Doomsday Survey, is said to hold as for a manor, though he may have no tenants. It may be worthwhile in this connection to allude to another general feature of the manorial estate on both sides of the Channel, which, if not directly of tribal origin, must at least have worked in close sympathy with tribal custom. The Gesticund man, officially charged with the control of a district or estate, easily became, in a manorial sense, lord of the dependent tenants upon it, and the judicial and magisterial adjunct to the lordship became a prevalent feature of the typical manor. We have seen that the sack and sock of later times may have grown from the root of the tribal principle, involved in the sacredness of the precinct or area of protection of the chieftain, and, in degree, of every grade of tribesmen who possessed a homestead. How large a place this principle occupied is shown by the prominence of the Freedis in Frankish law, and of the Mundbeard in the early Anglo-Saxon laws. The manor was a complex product of many factors, and tribal custom was certainly one of them. Once again, what kind of a holding was that of the 12 Hindmen? Was it a family holding, and what were the rules of succession? Unfortunately, we do not know how far the immigrants came in kindreds and families, or as followers in gesiths of military chieftains. But in any case, if we may take the evidence of place names, the great number of patronymic names of places which lead to the supposition that the holdings were family holdings. The Ham may at first have been the estate of a Gesigkund man, held direct of the king, with gaffageldas and gebers under him holding yardlands and doing work on his demesnes. But when it becomes an Ingham, the patronymic termination points to the lordship of the manor having been held, as time went on, jointly, in somewhat the same way as the Cymric chieftainship in the Gweli. His sons and great-grandsons may really have had their rights of maintenance all along, and ultimately, if they were allowed to do so, they may have sometimes divided the inheritance instead of continuing to hold it jointly. Tribal instincts working alone would probably follow some such line as this. But it is easy to see that the nearer the holding of the 12th Hindman approach to a beneficial office, the stronger would be the tendency towards single succession instead of divisions among heirs. End of section 36.